Okay, it looks like it's 7 o'clock, so with that, I'll go ahead and call the meeting to order. If everyone would join with me in a moment of silence first, and then John White will lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, if we can call the roll, please.
Councilmember Joe Cronin.
Here.
Councilmember Joe Brazel.
Here.
Councilmember Mike Elam.
Here.
Councilmember Mike Klinghammer.
Here.
Councilmember Dave Hammond.
Here.
Councilmember Councilmember John White.
Here. Okay, next we'll have the public comments part of the meeting. This is the time when members of the audience can address the council on any county-related business. Once a subject has been started, we'll have a total of 6 speakers on that particular subject. Each speaker will be given 3 minutes, and we'll alternate going back and forth between pros and cons on that particular subject. Is there anyone that would like to approach the council? Yes.
Did you look at this waterproofing pad?
Hi, my name is Rod Zaire, 15 Joan Drive, St. Peters, Missouri. I'd like to speak on the untimely activation of warning sirens this Saturday, June 7th, in the Harvester area. As you may know, we had a tornado event that hit about 3:42 that day. County warning sirens were not activated for at least 16 minutes from the National Weather Service activation. I think this is a critical thing, a life-critical situation that needs to be corrected either by staff or by the county council to make sure this doesn't happen again. When I was, when I was division director of emergency management, we always made sure that we had staff in the emergency operations center well in advance of these types of storms. I doubt if that was the case on Saturday, or we would have had more timely activation. So another thing I would like to recommend on the same subject is that I think it's time to appoint a new division director in emergency management. You have a captain now overseeing that. It also handles 5 or 6 other jobs. It's way too much for somebody to do that. You need a professional division director in emergency management to make sure that we have timely warning activations. Thank you.
Thank you, Mr. Zaire. Would anybody else like to speak on the subject of the alarms that went off, the storm alarms? Seeing no one else on that subject, you can approach next.
My name is Bob Mueller. Number one, I think just about everybody gets these books that shows what people get a hold of. There's nothing here for if you got a problem, like they call it neighborhood preservation. That's not in the book here. Planning and zoning is not in the book. If you want to get a hold of, hardly anybody has got a regular phone book nowadays. Everybody's got cell phones or whatever. And I think them 2 things should definitely be added to these books here, where we can readily get a hold of whoever we need on pertinent problems, Good point. Another thing, I don't know if this is the right time or not, but we've got a problem here at 2292 Circle Drive. 22 years ago, this trailer was brought in here unlawfully. I sent these pictures to you all. You can see all the rubbish and stuff was there. The creek used to come up right to the trailer. Over time, it's been built up. I've been on the county this was in 82, this was brought in. I've been on this ever since that was illegally brought in by Greg Leach. Since then, there's been 4 different people who have lived there. A fellow by the name of Michael Haniff actually had all this debris put in here. It wasn't Greg Leach. But it's been a problem all these years. It's built up, and then 2 years ago, Mr. Henderford bought the property, and they destroyed the old trailer that was there. I mean, it was an eyesore. It flooded many times, so this whole area is a flood area. I even got a flood area carved in this big sycamore tree that's right there, and everybody can see it. And now, since Mr. Henderford brought it, like I said, he demoed out the old trailer and brought in a new trailer. It come from Warrington, and he had permit, which he shouldn't have got, because this is illegal to have this trailer here because it's not grandfathered in. Anyway, it was illegally put there to start with. They brought it in on a Sunday, I think, a Saturday or Sunday years ago, 22 years ago, in 1982. Brought it in with a bulldozer and had to twist it in its place. Now, this toter driver that brought the new trailer in from Warrington, he's really knows what he's doing. He's got a new modern-day piece of equipment where he can twist and turn and do everything else with the trailer. He got it in there properly this time. But the trailer is right up where the old creek used to come to. Another thing, here's this piece of property. All you can use, it's 1.3 acres. You can only use this little part right down here because the creek that comes down Oak Drive is here. O'Day Creek, which is named Creek, comes right down the middle of the property. There's only maybe one, at the most, 2/10 of an acre that is usable. I've been mowing it for 25 years. I've been mowing this little piece of property because it's just right there adjacent to my property. But it just floods all the area. I mean, this is a critical flood area. And the fellow across the street put a berm in to keep the water to hit here and go on down into O'Day Creek. It's a serious problem. I've met with the Highway Department in the last 2 weeks. The head fellow in here, I can't think of his name, but it's in here. He met with me Tuesday. Pardon me.
We've got two people from community development here tonight. If you would you talk to them about it? And
I'll be glad to talk to anybody.
Okay.
Like I said, I've been working on this. 15 years ago, I made a complaint to the county. Okay, I finally had to get to the Army Corps of Engineers, which I made a complaint with them now, and DNR. So this has been an ongoing problem ever since that trailer was put in there 22 years ago in '82.
Okay.
And
I
it's
do
getting
know
worse.
that bill is on for introduction tonight, so we're going to be discussing
Yes,
it.
sir, it sure is.
In a little while here also.
Okay.
Thank you very much.
Thank you for your attention. Thank you.
Is anybody else here to speak on this issue?
I want to discuss the variances of it, but I was going to wait until after.
Okay. We've got a gentleman back here that rose first, and then you'll be next.
Hi, I'm Mr. Henneforth, and Ron Henneforth. I live at 2392 Circle Drive, and I own the property that the bill speaks of tonight. It's been going on for quite some time. I prepared, instead of going into all these details, I would hope that I could present a copy of the timeline to each one of you, and maybe you can just kind of go over the details when you have a chance. Basically, we're asking for a reversal of the denial, and hope that you can find the information in here, enough of it to come to an understanding, and I guess realize that from the very get-go, we tried to be upfront with this project. There was a lot of restrictions and a lot of challenges. So going into that, 20 years, I've been improving properties. This is what I do. I've never had so much resistance for over-improvements as I've gotten on this particular project. And I just want to, I guess, remind everybody that, being we're kind of down the street from the two largest rivers in this country where they come together, floodplains and situations like this. It's just, the way of life that we have to deal with here. But I'm hoping I could pass these out to you.
That'd be fine.
Okay.
And just to remind everybody, this bill is on for introduction tonight. So we won't be voting on it tonight. That'll be at our next scheduled meeting.
Yes, ma'am. Thank you.
Okay. Speaker card goes. Thank you. Yes, sir.
I'm Mike Vogley. I live at 2211 Circle Drive, and I want to appeal to this board to continue to deny the variances that has been requested on application 22071. I feel that it was a fair judgment when they denied these. They shouldn't be reversed. I don't even agree with the ones that they granted. They did grant them. I would like them reversed also. You've got a copy of that. I don't have to give you the copy of the thing. I don't see what his appeal is. He doesn't have enough property there to do what he's wanting to do. And if you don't have the adequate amount of property, you just got to have to do with what you got. I don't see where he can just come in and say, well, I have been improving property for a long time, and I want to do this, that, and the other. I'm not saying he didn't make the property look better. He did. But he's overextended, or he's wanting variances on, that's not necessary. He doesn't, I don't see where, when you put a piece of property in a floodplain, that you should be able just to do however you want to do with it and just come in here and say, I think I made this look better. You ought to grant this to me. I think it should be done. The denial should be withheld and not changed. That's what I'm asking this board to do, this council to do here, is to just uphold the denial.
Okay.
That he's already received.
Thanks for sharing your comments. Anybody else want to talk about the situation on Circle Drive? We usually only have a person speak one time. You're more than welcome to join us again at our next meeting. Anybody else that would like to speak?
Hi, I'm Lola Brand. I sent you all a letter or email several times in talking about this. What I have a concern is that this man just told us he has 20 years of doing this. 20 years of knowing that you don't ask for variances after you put a building already in. When we were at the zoning adjustment meeting, they being some county representative, said this man perjured himself. He said that that trailer was grandfathered into there, and there was no grandfather clause for that. So the building commission or whoever gives building permits was wrong in even giving a building permit to this man. This man was only given at the point that they thought there was a grandfather clause that he could put in, I think it was a 60-foot trailer, and he's extended it by 6 feet. So I have a real concern, one, that there was even a permit given for the man to put a trailer in that was an ungrandfathered clause, and the county rep said that they would not have approved it with all the creeks. You have agreements, the county has agreements with the federal and state, I don't know what organizations, that they're not supposed to be building or doing construction within a certain amount of creeks, and this is totally putting your agreement on the line. Should that ever, those county, the federal or the state committees come in and look at and review what you guys have approved. So I am asking that, yes, do not approve these variances. The variances that were approved should be denied, and the whole building permit should have been denied. Thank you.
Thank you. Appreciate you coming forward. Anybody else that would like to speak on this subject? Anybody like to speak on any other subjects?
Thank you very much, Mr. Chairman and members of the County Council. A.C. Dinoff, County resident. There's no question that I care about our St. Charles County as much as all of you, or in a lot of cases, more than some of you that are in front of me, or to my left, or to my right at the administration table. Treatment of that man sitting over to my right and to the right of the table, Mr. Harold Ellis, the county councilor, or your attorney for county government, treated me wrongly, unfairly, uncapricious, discriminatory, and yelled at me in the offices of below one floor below, which are.
Mr. Dienoff, we're not going to have personal attacks, so
I'm not going to have personal
keep it
attacks.
factual only, okay?
I'll refer to him as a county councilor then.
Very good.
I'm a public advocate, and I'm here to do the right thing and just thing for the benefit of our 400,000 great county residents. We as a county had a general municipal election on April the 8th. There were many election irregularities that have come into question of the county election authority director and its election authority that keep getting ignored by the county councilor and the administration and are being covered up by the current director and county election authority, including the director of administration and the county councilor. It is pathetic and is very sad indeed. I'm running for county election authority director because I want to be part of the solutions. On May 22nd, I filed several election challenges.
We don't talk about, you can't be talking about your election either, Arnie. We don't do that in the public podium.
You can talk about specifics only, but this is not a forum for you to talk about why the folks should vote for you. So
I didn't ask anybody to vote for me. I'm just making it a statement. So
keep it only to the facts.
And if I could have back my time, I would.
Keep it to the facts, Arnie.
On May 22nd, I filed several election challenges to the election and bringing points that our election system just is not transparent, open, fair, and not honest in numerous live examples and ways. But no one in county government cares. I will fight, and I will fight, and I will fight for county-wide, honest, and fair elections from here on out. I am tired of it. I'm tired of the administration sitting over there and not doing anything about it. The marching order from the Director of Administration and the County Executive are to squeeze Arnie Dienoff, hit him hard, and discriminate against him, making life in the court system as hard as you can. Those were the marching instructions given to Harold Ellis, the County Councilor. On May 23rd, I was directed by Acting Presiding Judge Aaron Burleson to go up the hill, this building, and speak with County Councilor Harold Ellis about the cause. The object and the treatment towards me is irrepressible. Mr. Ellis, the County Councilor, accepts service from other attorneys and other election causes without being served by the County Sheriff. But me, there's special rules and regulations. Yelling and mean treatment towards me as a human being and resident of our county will not be tolerated. I have never been treated by any county director or department head in this fashion or way. I am calling for an investigation by Mr. Ellman. There's a question about Mr. Ellis not being in compliance with the county home rule charter and his involvement with the Shaw neighborhood in the city of St. Louis.
Arnie, you come up here, you make unsubstantiated facts. You make claims and you insult people, and it's rude.
Right here's our county home rule charter that
you
there's a violation.
You cannot come up here and try to politicize. You're trying to run for office. That's exactly what you're doing. That's wrong.
Arnie,
we don't run our meetings that way.
Just a minute. I've asked you to keep only to the facts. You haven't laid facts out. You're making allegations without talking about specifics. In addition, the timer has gone off. I let it go longer because I did interrupt you before, but the 3 minutes has now expired.
Okay, then I'll be back at the next meeting with more irregularities,
very
and I will continue. And I do have a First Amendment right, and if you violate that, I'm going to challenge you.
You know what our set rules are. We've extended the time. Your time is now expired.
You don't have any rules. I am stating facts, and I don't need to be interrupted during my public comments. I don't interrupt anybody else, and I don't appreciate
Your
it
time
being
has
interrupted.
expired. Thank you very much. Okay. We do allow 3 minutes for people to speak. Is there anybody else? Yes.
I'm Marvin Stair, 813 Carolyn Jean Drive in O'Fallon, Missouri, and I'm here representing the Sheriff Preservation Initiative. Just here to let you know that after the 2012 Charter Amendment, a lot of people have discovered that it wasn't what they thought it was when they voted for it, and there was really about half the people voted for it and half voted against, so it was 7,200% margin spread. They're finding out that they don't like the idea that the chief law enforcement officer is going to be appointed police chief, not their elected sheriff. They didn't understand that part even when they voted, and they are willingly signing our petitions. We are picking up steam since spring has come in, heading to the summer weather. We were a little slow in the winter with this horrible winter weather we had. We're picking up steam. We're getting more volunteers coming on board. We're getting more signatures. There's a lot of petitions out there right now, so it's hard to tell exactly how many we've got.
Again, this is not a political forum.
I've got a proposal for you, actually.
Excuse me, sir. You have to talk about specifics, okay? It is not a forum to come and talk about any causes that you're trying to rally. Okay,
it is a fact that that amendment takes away the voters' rights to elect their chief law enforcement officer. And despite the county charter where it has different provisions, says this is what his rights or what his duties are, that particular sentence is one specific place in the county charter. It's still in the charter until the end of this year. It goes away on January 1st unless it's reversed. And what I say, we're picking up steam because we're going to get this on the ballot in November. I'm pretty sure of that. But I would invite the county council if they want to, be on the winning side. They still have in their power to put it on the ballot as well. There's some. Again, it's 90 days. I'm inviting you to do so. You're talking about a political issue that this isn't the forum for that. I'm talking about your job as county council. If you have the power to put that on the ballot, I'm inviting you to do so. Okay. If you want to be on the winning side. And you have up until 90 days prior to the election. There's been some misinformation out there saying it's July 4th. It's already expired. It's 90 days prior to the general election. And so that's basically what I have to say. I welcome you all and on board. I know there's people, they're coming, they're willing. So as one of the members of the council 2 years ago when this fought against this charter amendment, voted against it, said, and put out his liberty stick, was whittling on it. By passing the charter, that's county charter amendment, the law enforcement amendment 2012, took away liberties of the people. Thank you very much. Appreciate your comments. Anybody else want to talk about a specific issue that's related to the county? Okay. With that, we'll close the public comments part, and we'll open up the next subject, which is oral report from the county executive.
Mr. Chairman, I have a proclamation here, and I'd ask the following people if they're here from the Missouri Fraternal Alliance: Denise Comer, Ruth Hauser. Yeah, just come on up, Ruth. Justin Jacobs, Bill and Alice Meinhold, Grace Ruzi, Mike and Mary Darding, Travis Comer, and Dan Hauser. Is there anybody else that I missed? And why don't you just stand right over here and face the council so we can get you on TV, okay? Oh. Okay. Yeah, that's fine. Yeah, we get about 2 on one, or 3 on one side and 2 on the other. How's that? I don't want to get in front of you. Okay, I'm going to go ahead and read this proclamation, Mr. Chairman. Whereas in 1777, the Continental Congress adopted the Stars and Stripes pattern for the first official flag for our emerging new nation, celebrating the first Flag Day at the centennial of the U.S. flag's existence in 1877. And whereas many citizens and organizations advocated the adoption of a national day of commemoration for the U.S. flag, and on August 3, 1949, an act of Congress designated June 14th of each year as National Flag Day. And whereas later President Ronald Reagan signed Public Law 9954 recognizing the pause for the Pledge of Allegiance as part of National Flag Day activities, And whereas the American Flag Foundation, headquartered in Baltimore, Maryland, birthplace of the Star-Spangled Banner, was chartered to ensure that the true meaning and significance of the American flag is recognized. And whereas the foundation organizes many activities during the year, including a national pause for the Pledge of Allegiance event, and whereas it is the desire of the Missouri Fraternal Alliance that citizens across the United States join in the pause for the Pledge of Allegiance and take time on Flag Day to recite the pledge to honor our flag and all it represents. Now therefore be it proclaimed that I, Steve Elman, St. Charles County Executive, on behalf of St. Charles County Government, do hereby proclaim that citizens across our country pause for the Pledge of Allegiance as part of observation of National Flag Day, June 14th, 2014. Thank you, folks, for all you do, and we certainly hope that people will take this proclamation to heart and pause on June 14th. Thank you. Okay? Thank you very much. Okay, Mr. Chairman, the only other thing I believe I have to report on, just to give everybody an update on this whole situation with the MoDOT's request for projects. At first, we were going to go ahead, and as you know, this was something that was supposed to go on in, or at least MoDOT thought it was going to go on in August and September, where they put together a list of projects that they're going to propose that be done if the sales tax were to pass. That was moved from November up to August, and now all of a sudden what they've tried to do or had to do here is compress something that was going to take several months into something that takes several weeks. They sent us kind of just a request for us to send them projects that were our priorities in terms of road projects, and they had to have something right away, so we went ahead and sent them something because we always have a list of projects that we're going to be working on in the future. But I didn't want anybody to think that just myself or even just us, we're going to prioritize these projects that may or may not get done in St. Charles County, and that's why I asked you to go ahead and put on a public hearing or have a public hearing tonight for anybody to come in and have additional projects. We sent that request not only to you, but to the various cities. Well, then fast forward a couple days, and what we basically got was communications from MoDOT, which basically said, well, we like your list, but we think this ought to be on it instead, and we'd like this and like that, and that's fine. So what they are doing is to have their own public hearing on June 19th. So if any of you would like to present additional projects for them to consider, if anybody in the audience, if any of our cities, and we've heard from several cities, and we've invited them to go ahead and show up on June 19th. So once again, they have some road projects for us. If there are other types of projects that you think are important and you want to make them aware of them, if the cities or any citizens have other projects that they want them to be aware of, they need to show up on June 19th. We'll give MoDOT all the projects and let them decide which should be the priorities. Okay? Any questions on that? Thank you very much. If any questions do come up, yes.
Should I invite all the mayors for all the cities in my district?
We already did. When we heard from Wentzville today,
Good.
And they sent a letter and had some suggestions. We'll forward that on to MoDOT, and again, they can go ahead and anybody wants to add any projects to the list can, because again, we just dealt with the things we deal with, which is roads. But these funds, I guess, can be used for a lot of other things, for trails, for mass transit, for whole slew of things, sidewalks. And I know some of the cities have some other types of projects. So we just want to make sure everybody gets a chance to at least put their project on the table. And then ultimately, MoDOT will have to decide what they think is important and sell that to the voters if they think they have a chance of passing.
So what MoDOT's trying to do is come up with a list of projects and that the voters will know what it is that they're...
And again, they were going to go through a long, involved process to come up with that list. probably sometime in September for November, and now they got to do it now. And, it's going to have to happen a lot quicker. Anybody wants to have, anything to say about that, anything to add to the list, should do it. I mean, June 19th, I think, it's not really going to be an open forum on whether or not you like the tax. That's a whole different issue, which we can discuss later here or anywhere else. But they just want to know what projects people would like to see done so that they can put that out and tell them that, if the tax passes, here's what we're going to do.
Those are strictly state highways, right, Steve?
Yeah, we actually, that's another thing. Originally we were told it was just state highways, and then we found out that the city of St. Louis had some non-state highways, so we called them back, and they said, okay, you can put them on, and we did. We put Augusta Bottom Road on there.
That was my next question.
Yeah, and then we, was John here? John Grice here? John got a call a couple days later and said, we changed our mind. You can do non-MoDOT projects for trails and transit and some other, but you can't for highways. So anyway, they still know that's what we want to do, but they're going to have to make up their mind what the rules are, and this, like I say, we can have discussed for a long time, the proposal. But right now, we're just trying to make sure that anything anybody wants gets on the table so they can consider it. Okay?
Very good. Thank you. Appreciate that. Okay, next we have the consent agenda. Is there any items that any council member would like to remove from the consent agenda?
Talk about it. Yeah, I'd like to pull off the waterproofing bid off the agenda for discussion.
Okay.
Second.
Motion's been made to pull off the waterproofing bid under facilities. All in favor say aye.
Aye.
Aye. Opposed say nay. That one's been removed. Is there a motion to approve the remaining portion of the consent agenda?
So moved.
Second.
Motion's been made and seconded. All in favor of the remaining portion of the consent agenda say aye. Aye. Opposed say nay. Okay, let's go back then and talk about the waterproofing bid. You Cronin?
I'll let Mr. Brazel talk.
I just got a question about it. On this particular bid, Joanne, did you guys have a specification put together by any particular person?
There apparently had been a specification to do this work on the building a couple of years ago, and we refreshed that because it wasn't able to be done at the time during the...
Who put the specification together?
The specific person?
Well, was
I
it
can't tell you, it was done in facilities maintenance.
Okay.
I have a question.
Is it like a total restoration? Is it, do we know? I mean, when they bid it, was, do we have an expert that wrote the specs that knows what they're doing?
They did have some external help in doing it, and it's also been looked at by the state. As you know, we requested, with the help of Ryan Graham and the Parks Department, his help in getting a historic structures grant. And so we have a grant for 70% of this cost, and they've seen it as well.
Okay.
Is there a specific concern about it? I mean, we can...
Well, yeah. I mean, I didn't know. I wish I knew a little bit more, like if they're sealing the walls or they.
There's nothing in particular that has to happen tonight. If you want a chance to take a look at it, or for me to get.
I would prefer to, because this building's been leaking for years, and I just want to make sure that.
Yeah. No, but he understands that. You understand we're talking about tuck pointing.
Tuck pointing, caulking joints, sealing. I understand. I do it for a living. Yeah.
Yeah. No, I figured you knew that, but Bob was saying it's tuck pointing. But
yeah, it should be that's why I'd like to see the spec. I'd like to know if you're tuck pointing it and you got the equipment out. Are you caulking all the joints? Are you sealing it?
I'll be glad to send it to you.
Are you doing the sills? Are you replacing broken stones? Are you patching broken stones? Are you fixing hairline cracks? That's what I want to know. How extensive is it? Are we just doing like 20% of it? I mean, if we're going to do it, let's do it. And so it's been a scenario of what this county's been doing in past years. I want to make sure they're doing it right. That's all.
Glad glad to send it to you.
Okay, would you like to make a motion to hold that one?
I would like to make a motion. But Joe,
I have one question
Okay,
too.
sure, Mr. Cronin.
Councilman, just so you know, Jennifer just said we already sent it in the packet, so go ahead and table it tonight, but there's, unless I hear from you that you want anything else, you apparently have the whole bid in the packet,
okay.
the whole spec.
Okay, I have a question. Being it, I read the bid pretty closely, and the documents in it primarily is tuck pointing and a lot of caulking. And I only saw the two companies responded, and I wanted to. I'm sure there's plenty of masonry companies in St. Charles County, and these two companies are out of St. Louis County. So did Finance send this out to local contractors that can do this kind of work, and did they just not respond, or do these guys even know? Our county contractors know that this bid was let. Okay, and I guess that's my question to Finance about it.
Yeah.
Joe, I don't know the specific number, but I believe this bid was sent out to 7 or 9 different companies, and then this goes back quite a ways. So it didn't just go out on in the newspaper and advertised that way. There were companies that were contacted to let them know this bid was going out. I can get that for you.
I would appreciate it when we get all these packets, if it's possible. Can we get a list of who this was sent to? I just want to make sure the contractors in this county that are paying the taxes at least got a shot at the bid.
Yeah,
okay.
We can do that.
Is that fair?
Sure.
Thank you.
Thank you, Mr. Cronin. I think Mr. Brez made a motion that we hold this one over until the next meeting. Is there a second? Motion been made and seconded. All in favor, say aye. Aye. Opposed, say nay. The ayes have it. Okay. Next, we have resolution number 1405.
Resolution 1405, sponsored by Council as a whole. A resolution declaring June 14th, 2014 as Masonic Home of Missouri Day. Whereas the Masonic Home of Missouri, dedicated on June 15th, 1889, has for 125 years upheld the principles of brotherhood and charity. And whereas the Masonic Home of Missouri is a nonprofit charitable organization that provides assistance to eligible Master Masons, their wives, honored widows, female members of the Order of the Eastern Star, and children in need throughout the state of Missouri. And whereas our community of St. Charles County, Missouri has a Masonic Lodge, Mechanicsville Lodge number 260 in Defiance, whose members contribute to the well-being and quality of life for all citizens of this community throughout their own efforts in support of the Masonic Home of Missouri's outreach programs. Now therefore be it resolved by the County Council of St. Charles County, Missouri as follows. Section 1, the St. Charles County Council hereby proclaims June 14, 2014 as Masonic Home of Missouri Day throughout St. Charles County, Missouri. Section 2, the St. Charles County Council hereby further encourages all of our citizens to recognize the Masonic Home of Missouri and Mechanicsville Lodge number 260 in Defiance for the impact they have made and continue to make in our community.
Thank you. Is there a roll call necessary for a
It is, yes.
resolution? Thank you.
A resolution declaring June 14th, 2014 as Masonic Home of Missouri Day. Councilmember Cronin?
Yes.
Councilmember Brazel?
Yes.
Councilmember Elam?
Yes.
Councilmember Klinghammer?
Yes.
Councilmember Hammond?
Yes.
Councilmember Hollander?
Yes.
Councilmember White?
Okay, next we have bills for final passage. We have one tonight, bill number 4094.
Bill number 4094, an ordinance authorizing the county executive or his designee to execute an intergovernmental agreement with the Missouri Department of Health and Senior Services, Bureau of Community Health and Wellness, and the St. Charles County Department of Community Health and the Environment related to a grant receipt of up to $500 for workplace lactation support.
Any comments or questions? Roll call vote, please.
An ordinance authorizing the county executive or his designee to execute an intergovernmental agreement with the Missouri Department of Health and Senior Services, Bureau of Community Health and Wellness, and the St. Charles County Department of Community Health and the Environment related to a grant receipt of up to $500 for workplace lactation support. Councilmember Brazel?
Yes.
Councilmember Elam?
Yes.
Councilmember Klinghammer?
Yes.
Councilmember Hammond?
Yes.
Councilmember Hollander?
Yes.
Councilmember White? Yes. Councilmember Cronin?
Yes.
Thank you. Next we have bills for introduction.
Bill number 4095, requested by Wayne Anthony, sponsored by Joe Brazel, an ordinance reversing the Board of Zoning Adjustments decision in Variance 22071.
Any questions or comments at this point?
I'm
Mr.
sure
President?
there are, yeah. Dave, you want me to ask some questions with Robert, or you want to start?
Yeah, Robert or Wayne, I had some questions.
Who's doing this? Robert, could you come up here, please? On this, Robert,
Yes.
we received a lot of calls and emails and so forth, and Mr. Ron Hernfarth, I read his application, and I talked to him on the phone. I talked to Mr. Mueller, and I talked to some other neighbors in the area. Can you kind of give us a rundown here on from what I understand, was a lot of this stuff done without permits, or can you just give us the rundown of the facts?
I'll just give you a quick overview. I'm Robert Myers, the Planning and Zoning Division Director, and the quick overview is this. This lot at 2392 Circle Drive is located just outside of O'Fallon in an unincorporated area off of Double D Highway and Summers Road. And the lot's a little over an acre. There's 2 creeks that flow right through the middle of this lot. So to do anything with the property is very, very difficult. It had a mobile home on it since the early 1980s, and from the best of our records, there was not a permit issued for that mobile home. The lot was created back in the 1960s. But Mr. Hinterforth applied for a permit to replace the mobile home with our department. And he was informed that if it was replaced exactly the same size and location as the old mobile home, that it could be, the new mobile home could be placed there. But anything else would require variances if necessary and permits. We started receiving some calls and determined that in addition to placing the mobile home there were some other improvements being made. There was a carport that was erected without a permit, a fence, removal of the vegetative buffer along the creek, which is literally right up the back of the mobile home. And so in following up on these apparent violations, we determined that there's no possible way to even basically get permits without the possibility of variances. And so Mr. Hinterforth applied for variance for the carport, and that initiated this actually whole series of related variance applications. So there were 5 variance applications, variance requests being considered by the Board of Zoning Appeals, Board of Zoning Adjustment, excuse me, and they approved 2. And those 2 variances had to do with the mobile home itself. But they denied variances for the other things that were needed, such as the carport side yard setback, the carport setback from the street, and also a variance to remove the vegetative stream buffer. So those 3 were denied.
So regardless of tonight's, we're just voting on those 3 items. See, the mobile home, no matter what, has already been permitted to be there, correct?
The mobile home has a permit to be located there, and there now is 2 variances in terms of the setback and the side yard setback variances.
Is the mobile home larger than the last one that was there?
To the best of our records, it is slightly larger than the home that used to be there, and that's actually why we recommended to Mr. Hinterforth that he apply for as long as he's applying for a variance for the carport, to also add the 2 variance requests for the mobile home itself, because it's in the same location, but it's a little bit larger.
So what this ordinance is it has nothing to do with the mobile home. Is that correct? What we're voting on next meeting. It's not. Is that right, Dave? That's what I understand. It's just a mobile home, or it's just a carport, the buffer, and the third item you mentioned. But the mobile home, as far as the county, as far as what we're talking about, has already been permitted, correct?
Well, there is. That's true. The mobile home, yes, but there's a deck built on the back of the mobile home that actually encroaches within that stream bank buffer. Literally, the mobile home is right up against that.
So I just want these folks to understand that this has nothing to do with the mobile home itself. If we don't pass this, it just says he has to remove his carport and his deck and whatever else that's violating the variances, correct?
That's what these variance requests are about, yes.
Okay, so just so that's understood, I mean, because I think some people think that that we're voting on having the mobile home removed, and I don't think that's not what this ordinance says. I'll ask you, hold on, Bob, I'll just ask you some questions. we got, yeah.
This would reverse them.
What's that?
Yeah, maybe I'm confused then.
I think what they're asking us to do is reverse the denial of those 3 items, but the permit for the mobile home's already been approved, so we can't. This ordinance that we're dealing with tonight has nothing to do with the mobile home. It just has with those other 3 items. Correct, Bob?
Yes. That's correct.
Question. I'm sorry, Dave, go ahead first. And then
Question for council. Can we go back, the 2 items that were approved by the Board of Zoning Adjustment and reverse those? Or are we bound?
If an aggrieved person appealed to you from those decisions, you would be vested with authority to reverse them. But there is no appeal to you that I know of, that I see in your packet on those 2 points. So you do not, you can't open up those questions. Those are now closed. But in front of you are the questions about the stream bank buffer and the deck in it, and the various setbacks for the carport built up against the mobile home.
Mr. Cronin.
2 questions for you, and I guess a comment as well. Is this property where this mobile home sits in the floodplain?
No, technically, no, not currently. If you look at just the approved maps today, it's not in any regulatory floodplain, but we've received lots of reports that it does flood, and we understand from the new, more accurate maps that are not yet adopted, not yet approved, that should those maps be adopted, then this would be within floodplain and close to a floodway.
Okay, and I saw a lot of the pictures that were in the packet. If the variance for the vegetative buffer, okay, is not granted, okay, doesn't the mobile home encroach on that vegetative buffer? So how can you have the vegetative buffer and the mobile home if one encroaches on the other?
Well, the deck that was added definitely encroaches within the vegetative buffer. The mobile home itself, I think there's a corner of it that encroaches in the vegetative buffer, but I think that's the reason why the applicant was instructed to just place a new mobile home exactly on the pad side of the old mobile home, so it wouldn't encroach any more than it did, the old one did from the early 1980s.
So if the mobile home encroaches on the buffer, don't you have to have the variance to allow the mobile home?
Yeah.
Well, that is, it was determined that if they replaced the new mobile home for the old one, that it would not be any more of a violation setback than the old mobile home, and that it would be acceptable, essentially grandfather.
Okay. And then I just have one comment for these folks too, I guess. I saw the book that y'all held up. That's a state book, so that's why we're not in there. But I think what they're trying to, what Mr. Ellis was trying to tell you folks, the neighbors, that if you want those other variances that did get approved, if you want those overturned, there's a separate action that you're going to have to take besides what's presented to us now. All the thing we're voting on is whether or not to overturn the variance for the carport, the variance for the, or to overturn the variance that was denied for the carport, the buffer, and the deck.
What about the addition? He just mentioned next. The addition is on that trail when he bought it in Warrington.
Wait. We don't take comments from the audience at this time.
Yeah. No, that's all I have.
Mr. Chairman?
Yes.
I have a question. I hope everybody understands that all these things could have been before you if the aggrieved party had appealed them. But my question for the county councilor is it too late to appeal them? Because usually you have to appeal these things within a certain amount of time or something.
Yeah, the ordinance does have a time limit on the time for
Hold on
appeals.
just a second, guys.
The appeals have to be taken within so many days of the decision. The decision was on May 1st, if I'm not mistaken, and we're well past even a 30-day period for taking the appeal to the council. And I believe actually that the period in the UDO, I don't have it in front of me, is 15 days, 15 working days. I don't have the UDO in front of me, so I can't answer that question for sure.
Can I ask how come you want to have a meeting within the 30 days then? Or we can, that's why we're here to appeal this. The last meeting was on May the 1st. This is June the 6th. That's more than 30 days. Why wasn't there a meeting within a time frame where we could appeal it?
The appeal is taken in writing to the council, then put on the council's agenda.
Should he have got a letter stating he had the right to appeal though? How are we supposed to know that?
Yeah, how are we supposed to know that?
Mike.
That's not right.
Okay.
That's why we have these meetings, so we can appeal. That's what we're here for.
This isn't the forum to make the appeal. The appeal is supposed to be done in writing so that it would appear on our agenda.
Nobody explained that to us at any meeting.
Right. Mr. Brass.
I just, I'm trying to confuse, this is really messed up. If somebody has a trailer they put in 30 or 40 years ago and they just put it in, I mean, things were different, we get it. It was a charter county and all that other stuff, and they didn't get a permit or whatever. Who knows what happened, okay? I'm a little confused why that grandfathers it, because things change over all this time, and that's not really a mobile home type area anymore. And so what I'm concerned about is if you had a house that you tore down, you would have to get a building permit and follow the new codes and everything. So I'm concerned, did the gentleman get the permit? He got the permit and then he moved the mobile home in there, is that correct?
Yes, yeah, 2 permits, one to remove the existing mobile home and one to install the new one.
Why was that permit granted? That's the crux of what I don't understand. There wasn't supposed to be one there, and it was there. Okay, it somehow it was there, but why did we continue being wrong? I mean, it shouldn't have been there to begin with. So I'm trying to understand why our department went ahead and issued another permit for something that shouldn't have been there to begin with.
Well, you got 2 problems here. Now you got a bunch of neighbors that are unsatisfied, as I would be, but then you got the gentleman who followed the process and put a mobile home there and got the application. So you got 2 bad issues here, you know.
Right, and then it was exasperated by adding on to it with other structures and taking the vegetative buffer out. Okay.
Yeah, I mean, Bob, I don't know what else to ask you. I want to ask Mr. Mueller a couple questions whenever you guys, if you do. Dave, you got anything?
Any other questions?
I don't think I have any more questions of planning and zoning, but I wish there would have been an appeal because I would have not voted for any of these variants that were granted. So to begin with. You know, we've already had our public comment, and you've had your opportunity. We'll have another meeting to speak about this again. This is only the first meeting.
Okay.
I think I've got some questions for legal counsel.
We'll ask those later?
Yeah, I'll ask those later.
Okay.
Okay, yeah, I want to ask Mr. Mueller. Bob, thank you. I want to ask Mr. Mueller. You can come up to the podium. I want to ask you some questions.
I didn't realize the 3 minutes was already here. I'll wait.
No, you're fine. Come on up here now. Okay. I want to ask you some questions. Now it's our turn to talk.
Sure.
Okay. You called me. We talked on the phone.
Yes, sir. Yes, sir.
The other issues that we're talking about is the creek, which is a separate issue, and the county's doing the hydraulics of the creek and the bridge and all that. So we got that covered, okay?
Yes, sir. I understand.
All right. Craig Drakowski went out there with the engineers. They looked at it. They got that squared away. The issue with the trailer is you understand that right now And I guess we'll talk to Harold and see what avenues are, but I do agree that trailer's not a good fit for that neighborhood. I agree with that.
Well, here's the problem. He lied on the application to planning and zoning that that trailer was grandfathered. That's what we all just stated. The trailer should have never been put there in 82. And when he applied for the application...
We understand that. I think there might have been a follow-up somewhere. I don't know. But the fact is, what this body is looking at right now are just those 3 variances.
Okay. You got the Clean Water Act, Section 404, that states you cannot be within 25 foot of the creek. That trail is right up next to the creek. I mean, right there. So there's no way you can have a variance to start with, because the Clean Water Act, the Federal Clean Water Act, Section 404, states you have to have a 25-foot buffer. And that's what he's asking for you gentlemen, which you can't override the federal government, to get his setback from 25 foot to 0 feet, which he knows he's right on the creek. But he's
I don't think you got to convince. You don't have to convince me about these variances.
The trailer should never be there to start with.
But I'm just saying right now we got a legal issue with that one. So, but the variance is something that we can.
Well, we are all struggling want to be here, and that's why we're here to help you people decide that there should be no variances approved, period, and that he has to remove that trailer.
That's not the ordinance.
That's not before us on this one. I mean, there may be actions that we can take.
Well, I mean,
we'll talk to our council about what we can and can't do, because unfortunately, he was issued a permit. So we got to work that quandary out still.
But if he's denied the variances, that means the trailer can't exist there, period.
No, the variances are just on the deck, the carport, and the berm. Those are the only things that's on our.
Well, the point I'm getting is, he brought a trailer in and was authorized a permit to put the same trailer in there. You're not understanding. Here's the trailer here. He put an addition on this trailer, plus a deck, and now the carport's alongside of it. He also built a berm, which is halfway on my property. And they told us at the last meeting, his girlfriend swore under oath that they would have that removed. It has not been nothing removed at all. And of course, it's over 30 days. Like he said, 1st of May, it's already the 9th of June. I'm going to charge him at least $2,500 to remove off of my property if I have to.
Well, like I told you, I'll come out there. I'm going to look at it again. But,
yes, I'd invite all you gentlemen to come out there and see the situation. We got a major problem with O'Day Creek and the creek along Oak Drive. I invite every single one of you to come out and see the situation we got.
Well, and I think that's part of what's compounding the confusion here, is that we do have separate issues, and they keep getting blended together.
Well, it is all within 200 feet.
Right.
It's all within his property, within Mr. Henderford's property. This whole catastrophe are complex issues.
But what's before us right now is only those 3 variances.
Well, like I said, if the variances are denied, then the trailer's got to go, because he can't have anything. But it's a simple like put to you. I got all the pictures. I even got a video that Mike Vogley took of when the trailer floods. I mean, it floods, and with all this new development in the area, Walmart and Lowe's and all up in Lake St. Louis, all that water comes down through mine and his property.
Okay.
I mean, we got a problem. Like I said, we got multiple issues, which you gentlemen need to come out and see, and then you can get a broader picture of what's going on in the area. Right. And I strongly advise you to get a hold of me anytime you want.
Yep. Yes, sir.
Can I say something?
Not right now. Okay. We will get back to that in just a moment, though. Mr. Cronin.
I'm looking at the permit for that mobile home from 2012 where he moved it in, okay? And on the application, there's a question that's asked. It says vegetative buffers of 25 to 50 feet must be provided along natural water courses. There should be no clearing, grading, etc. And at that particular spot on that application in 2012, he put an NA, not applicable. So I would think that makes this application not truthful, being that it's obviously closer than 25 feet.
That's a question.
That's a question for legal down the road.
Right.
But it's on page 126 of the packet, Harold.
Okay. I think I understand where staff's coming from, in the sense that there was already an improvement there is on that particular location where the new mobile home was moved to. So I don't know the legal aspects of how that.
What improvements?
The existing site where the previous home was located, the mobile home.
He didn't approve nothing.
Okay, we're gonna cut off the back and forth discussion now, and I really it pains me to do that, but this isn't the forum for that. We've got some questions that we're going to get answered from staff, and it will be on our agenda at the next meeting.
I was just going to ask Ron, Mr. Hennifer, you want to come up here? I got some questions for you. So, we talked on the phone and you gave me your side of the story, but on the mobile home thing, you bought the property and you got a permit for the mobile home, correct? And then you moved the mobile home on there.
Yes, sir.
And then the other things that you did not get a permit with the carport, the deck, and the fence. Is that you did not get a permit for? Then you went back to get a permit. Is that correct?
That's correct. After the inspector came out, she said all I needed to do was, pay for the permit fees, and we're talking about 4 pieces of privacy fence, just as a visual buffer. We're not talking about 200 feet of fence here. The berm itself is a protective measure. When the creek jumps the bank at Mr. Mueller's unpermitted low crossing that he has created in his 500 feet of creek that he's been filling for the last umpteen years, that is where the water will jump out of that bank and come down. The berm that I created is nothing more than a break for the water to shed off both sides and protect the home. Besides that, there was a home in Pinto Circle. I had sent the email before I purchased it to Jan Whipple, and I had noted on there the addition. They call it an addition. It's an actual slide manufactured with the home. This is how they were made. And she had given me approval for that purchase of that home in Pinto Circle. And I have a copy of that email, and I have the picture with the circle and the indicating the bump out. And because of the existing structure on the existing home went out 8 feet, and the slide on that particular home only went 6 feet, she granted me approval. I had the green light. I purchased that home 2 days later. Now you can look on there, and the home is still there, and you can measure it as a 1480 with a slide.
But that addition don't have anything to do with this ordinance, so not this variance.
No, what I'm saying is I didn't just go out and buy a home and try and sneak something in there that was larger. It was in 2 different places in the county records at that time, listed as separately as a 1480 and in another area as a 1460. So the records conflicted each other as far as what exactly that was there. Like I said, I had approval to buy that home, and 2 days later I purchased it. The logistics of moving it had some outbuildings and some things that turned out it was just going to be too much to move. So I never moved the home, but I went out and purchased a smaller home, 1470, which is actually a 1466, where the new home, I'm being told, was a 1462. So we're talking about 4 feet here, if that is indeed the case. Aside from that, Rocky Morgan and I were on a first-name basis throughout this whole project. Every step of the way, he received phone calls down there from the neighbors, and I understand. I get it. They didn't want an old derelict mobile home bringing down the value of the property. I understand that. The property had challenges, and I've been doing this for a long time, and I knew I could make something of the property, make it nicer. My problem was trying to make it too nice. My understanding is if you make something nice, you're going to appeal to a little bit, a higher quality of person that may be wanting to live there, and that was my goal. Originally, the neighbors were worried about their property values, and that was the main concern. And now it's focused. Now it's a flooding issue and all these other things. And if to me, I wouldn't want a single-wide mobile home. I have tried to make it look as conducive to the neighborhood as possible. I could easily, I guess, put the thing on stilts 10 feet in the air, but my feeling is, let's make it nice, let's make it attractive, and somewhere somebody would be proud to live in. I know it's only a mobile home, but unfortunately, the size of the lot, the usable portion of it, there's not much else you can do there.
All right, thank you.
And the main thing, the main concern when I was talking about moving in another home was not to put it any closer to the street. That was more of a concern than putting it closer to the creek.
Thank you very much.
Mm-hmm.
Any other discussion on this item for tonight? Seeing none, we'll move on to the next bill for introduction.
Bill number 4096, requested by Bob Schnur, sponsored by council as a whole. An ordinance amending sections 650.040 and 650.050 ordinances of St. Charles County, Missouri, OSCCMO, relating to licenses to keep a ferry.
Questions or comments? Seeing none, read the next one, please. Oh, I'm sorry.
Yeah.
Joe, I didn't.
Bob, on this bill, is there any reason why are we doing this, and did we contact the ferry vendors to let them know that we're doing this?
We've not, as far as I know, we've not contacted the ferry vendors. Typically, our historical practice has been that when any of the ferries come to us to renew their licenses, there was a requirement in our ordinances that required them to provide a bond. The requirement for that bond is, as I understand it, kind of a historic requirement when ferries were a more crucial means of commerce and transportation, which no longer really fits the mold of what our ferries are about. They're more recreational in nature. So historically, and I don't know how long it's been going on. It was going on before I got here. It was while I know when I was still on the council. We would just routinely waive the requirement for the bonds. Recently, several months back, there was some discussion about a bond application, and it was brought up that, well, should we at least make sure that they've got the proper insurance? So that's part of what's being added here, that we make sure that they've got the proper insurance, but we can still waive the bond requirement.
So, Mike, did you talk to any of your
I haven't heard from any of them on this. So,
but were they notified, like Pete Tully? And how many ferries are there now? Just one, or are there two?
I think there's 2 or 3: Grafton, Golden Eagle, and maybe one other.
Those are the 2 I know of.
Maybe just 2.
I don't think Pete Tully's involved in the Grafton anymore. I think the city of Grafton actually.
Yeah, this was just an attempt really to make sure they've got the proper insurance in place before we issue the license. We did not have that requirement before, but basically still not requiring them to put up the bond.
Well, is it easier for them to get the insurance rather than the performance bond?
Well, they have to have insurance in order to operate. The
but
bond
so what this is saying that in lieu of the performance bond, so we're waiving the performance bond.
I think that the ordinance actually says that the council may waive the bond, and if they do, then the insurance is required.
Right, but the insurance was required anyway. That's the part about this language that doesn't make a lot of sense to me.
It wasn't required as a matter of our ordinance, right, Harold?
No, insurance is required of them under other laws and under diligent business practices. We just want to make sure that they have adequate insurance.
Okay, so we're not requiring them to do anything that they didn't have before.
Right, but when you say adequate, is the insurance adequate? Is it what they're normally getting, or is it like much higher standards that would make it unaffordable for them? That's the only concern I have.
No, it's typical. Did we mention liability limits, Harold, in the ordinance? I don't remember offhand. No. So what we would consider normal liability limits of like $2 million, that kind of normal commercial coverage.
Okay, Mr. Cronin?
I think that county needs to get a hold of the Ballman brothers that run Golden Eagle, simply from the fact to make sure that this is not a problem for them. If they say, hey, we've already got that insurance covered, it's not a big deal, I'm fine with this. but I kind of disagree that these are only for tourists, because I can tell you, there's a ton of people from Calhoun County that come over to this county every day in business, and I send my trucks to Calhoun County across that ferry some too. So I think the Ballman boys are the ones that run Golden Eagle, and I think they're the prime ferry that we have in the county now. And I know you want to have them insured, but I just want to make sure we're not creating any type of hardship on those guys.
That's all I'm asking.
Yeah, I sincerely doubt that, because of the commercial enterprise that they and any other ferry company operate, they're going to have that coverage in place to satisfy the Coast Guard and whoever else has oversight over their operation.
This is the way I kept reading this. It just codifies it that we can waive the performance bond without a separate action.
Correct.
I mean, the insurance was required anyway. Dave?
This is a performance bond? Is that what it's really
waiving.
called?
No, which is a little bit cumbersome. The law is that they have to have a bond to ensure performance of their legal duties. Their legal duties are not defined, but they do have legal duties to protect the clients and cargo that they take on their boats for pay. And that's covered by insurance.
Yeah, I'm not sure why we even require a bond, to be perfectly honest.
The state statute did, Councilman. That was the problem that came up earlier in the year when Bob was waiving one for the Golden Eagle. We went back and read the statute, and the statute doesn't actually have a provision in it for waiver. So
I see.
We need to provide for that.
Okay. Well, that makes sense.
Okay. We can check with Golden Eagle if you'd like.
I'd like to know that. I know those guys struggle to provide a service that's really important for a lot of people, and I just want to make sure we don't put any hurdles up they can't jump.
No, I'm sure the case is not, but we'll verify.
All right, thank you.
Okay, bill number 4097.
Bill number 4097, requested by Wayne Anthony, sponsored by Mike Klinghammer. An ordinance amending sections 120.4070.A and 120.670.A, ordinances of St. Charles County, Missouri, OSCCMO, revising annual reporting requirements for agencies funded by the Community Assistance Board and Domestic Violence Board, approving a forum contract for the Community Assistance Board, and adopting a modified forum contract for the Domestic Violence Board.
Questions or comments? Seeing none, let's move on to the next one.
Bill number 4098, requested by Craig Tykowski, sponsored by Mike Klinghammer, an ordinance implementing a schedule of rates and charges for aircraft parking at Smart Field.
Questions or comments? Seeing none, we'll move forward.
Bill number 4099, requested by Tom Neer, sponsored by council as a whole, an ordinance enacting a new section 200.045, ordinances of St. Charles County, Missouri, OSCCMO, establishing and providing for the collection of fees for processing of initial sex offender registrations and changes to such registrations.
Questions or comments? Seeing none, we'll move forward.
Bill number 4100, requested by Sheriff Tom Neer, sponsored by Mike Klinghammer, an ordinance authorizing the county executive to execute a memorandum of agreement between the Federal Emergency Management Agency, FEMA, and St. Charles County for access to IPAWS-OPEN by interoperable software systems.
Any questions or comments? Seeing none, we'll move forward.
Bill number 4101, requested by Steve Ellman, sponsored by council as a whole, an ordinance establishing the Radio Communications Policy Commission and further establishing a standing advisory committee of that commission to be known as the Technical Operations Committee, both for the purpose of making recommendations to the county executive related to the operation of the St. Charles County P25 land mobile radio microwave system for public safety and emergency communications.
Questions or comments?
I got a question.
Yes.
Steve or Joanne or whoever, is there any reason why a county council members should not be on there to know what's going on, or is it not something that we should be involved in?
Well, it's operational, so normally you wouldn't be on something of an operational nature like that. But if you all want an ex officio member on there, it can be amended.
I don't.
No, we can talk about it later. I mean, I don't particularly, I don't want to do it. I just.
There's somebody else.
I nominate Mr. Brazel to serve on this one.
I second Brazel being there.
No, I'm not interested.
There's one member from the, I'm reading the different members, there's one from the county police department, county sheriff's department, so they could report to us about it too.
Sure.
Sure, okay.
You asked the question. It's yours, man.
No, that's it. I'm done. That's all.
Seeing no
Is that
other-
the only representation from the county? Is the sheriff's department the one person?
No, there are others. There's also the director, I think, of dispatch. I'm trying to flip through the page, and then we also staff it, and the member of the commission.
Okay.
Sounds like a great job for the retired sheriff of this county.
Okay, yeah.
Let's read the next one, please.
Bill number 4102, requested by Steve Ellman, sponsored by Mike Klinghammer, an ordinance authorizing the execution of a business associate agreement between the County Dispatch and Alarm Department and the St. Charles County Ambulance District.
Questions or comments? Seeing none, let's move forward.
Bill number 4103, requested by Don Holt, sponsored by Mike Klinghammer, an ordinance authorizing the county executive or his designee to execute an intergovernmental agreement with the Missouri Department of Economic Development, Division of Workforce Development, and the St. Charles County Department of Workforce Development related to a grant for receipt of up to $21,600 for temporary assistance to needy families, TANF.
Questions or comments? Seeing none, let's move forward.
Bill number 4104, request by Steve Ellman, sponsored by Mike Elam and Dave Hammond, an ordinance establishing a working group for St. Charles County government in order to foster an employment-friendly environment for those who have served in the armed forces of the United States, further establishing an award of appreciation to recognize employers in St. Charles County community who are working to develop their businesses as veteran-friendly places of employment, and directing the Finance Department to amend county bid documents to call on bidders to indicate whether they have developed veteran-friendly employment policies and to provide copies of them for information.
Mr. Cronin?
Since Mr. Holt's here, I just have a question. Years back, I have hired veterans for my own business through state programs that were available to assist. Is this something that we're going to do in addition to that, or is this something that your office will be working at to help these veterans coming home find jobs, or how's this going to work?
I am not real familiar with this particular bill. I mean, we do things with veterans that are returning, and and of course, we will work closely with any effort in the community to help veterans returning in obtaining employment.
So will this kind of be something that you folks are proposing to work?
Mr. Chairman?
Please. Yes,
May I
yes.
answer Mr. Cronin's
Yes,
question?
Steve, go ahead.
Yeah, this is in addition, Don, this is in addition to anything the state already requires. And just to give you some background on this, last year the entire staff went down and met with Eric Greitens, who's the former Navy SEAL whose program is, help me now, the mission continues. And we went down and just said, hey, is there anything that we could be doing, that would help these Persian Gulf and Iraq and Afghanistan vets, especially the ones who are coming back. And he put us in touch, was it the Chamber of Commerce of Arizona Chamber of Commerce, and Joanne spent a lot of time looking at what they are recommending. And just to give you some idea on what this is, it's not a preference. What it is an effort to, first of all, make sure that people getting out of the armed services know about any employment opportunities. So we'll make a point of going out to the military installations and make sure they know about it. We will have a person in HR, which we'll ask you to approve in the budget next year, who will in fact be a veteran of one of those wars that will then hopefully help us better understand the problems that those veterans would face if they came back and worked for us. And the third thing that I can remember here is that we actually look within our own workforce, and we were surprised to find out how many veterans we actually have working for us already. and to put together sort of a committee where they can get together and any new veterans coming in can, help them learn their way and make the adjustment better. And we're not just talking about, PTSD here. We're talking about a whole lot of challenges that these veterans face that many of our other new employees don't. Joanne, do you want to add anything to that?
Yeah, I think one of the main pieces of advice that was in the information that came out of Arizona is how important it is to provide some mentoring within the organization, hopefully veteran to veteran, so that if they have questions about not only our benefits but about their military benefits, that there's somebody to guide them, that you can go here or you can go there. Those things that we take for granted that are available to them aren't always apparent, and so part of what they really recommended was to try to create a culture where they know that they've got somebody that they can reach out to, and also maybe to start to get those families together socially for whatever support they need.
Mr. Chairman, just to continue on that, obviously if and when you approve this and we go forward with it and get it all set up, then we're going to challenge private businesses in the county to do something similar. And if they do that, we'll give them some sort of recognition. We also are going to ask all of our bidders when they submit their bid just to tell us whether or not they're doing anything like this, again, to make them aware that some companies are, in fact, doing this. So, you may be able to improve it, but it's something we've been working on quite a while, and I think it's something we need to do for these younger men and women that are coming back, trying to get back in the workforce. And Don probably can tell you a lot more about their problems and what assistance is already available, and we'll hopefully be able to do some things here within the government too.
Thank you, Mr. Elman. Any other questions, Mr. Cronin?
So basically, it would be working in conjunction with all the programs that Mr. Holt's already doing, just supplementing and trying.
Yeah, we're not going to duplicate anything that he's already doing.
Do you anticipate would that person be working then out of his office or in conjunction?
No, a person would be working in HR with us to help us recruit and interview people, and I think that's the main idea of.
Right. And to work with existing employees we have who may need assistance.
Okay.
And that part, you're not approving that yet. We'll have to come back and sell that to you all when we do the budget. And you'll have plenty of opportunities to ask questions about that last part of it. But that is part of the plan.
Okay. Thank you. Appreciate that. Any other questions or comments? Let's move forward to the next bill then.
Bill number 4105, requested by Steve Elman, sponsored by Mike Klinghammer, an ordinance waiving liquor license fees for certain concessions operations of the Parks and Recreation Department of the City of St. Charles for the period July 1st, 2014 through June 30th, 2015. Whereas the St. Charles County Parks and Recreation Department requests the fees for liquor license for certain concession operations of the City of St. Charles Parks and Recreation Department be waived. Now therefore be it ordained by the County Council of St. Charles County, Missouri as follows. Section 1. The county registrar is hereby authorized and directed to waive liquor license fees for the City of St. Charles Parks and Recreation Department facilities in Blanchette Park, McNair Park, Mueller Park, and Wapplehorse Park for the period July 1st, 2014 through June 30th, 2015. Section 2, this ordinance shall be in full force and effect from and after the date of its passage and approval.
Questions or comments? Seeing none, let's move forward to 4106.
Bill number 4106, requested by Steve Elman, sponsored by Mike Klinghammer, an ordinance amending Chapter 115 of the Ordinances of St. Charles County, Missouri, OSCCMO, relating to the basic pay plan for a position within the St. Charles County Department of Community Health and the Environment, and further amending the 2014 budget adopted by Ordinance 13-092.
Questions or comments on this one? Seeing none, let's move forward.
That was it for the bills for introduction.
Okay. Mm-hmm. Is there any activity on tabled bill?
Yeah, on bill 40, there is a substitute bill 4087, but I was talking to Holly, or one of our counselors, and we're still working on some things. most of it's okay except for the dispute over the grapes. You know, I'm trying to work that out. I think most of them are going to be satisfied with the 50% rule, and there's just some other tweaking we're going to do, and so they wanted. I told them the next meeting we're having this next meeting. We're gonna because one of the wineries had plenty of time and he never sent me something like he said he was, and so I put the substitute bill together, and he said he would definitely have it for the next meeting or prior to, like a week prior to, so everyone has time to look at it.
Right.
There was some concern about the 85% rule, but I don't think that has anything to do with us. That's already state law on the Missouri wine part of it. So yeah, we're working through it.
Very good. Do you think we'll need a public or a work session?
I don't know. Well, let's try to get it out. I'll get it out a week before, and we'll see if there's if everybody seems happy with it, then there really wouldn't be any. So let me just see
how it goes closer to that time.
Yeah.
Very good. Okay. Yes.
Question for administration. What happened with was there a problem with our sirens down in Harvester? I know mine went off twice that particular day. Are we aware that we had it?
The normal circumstance is that there is a national, we staff up the Emergency Operations Center. There's normally a telephone call with the National Weather Service to kind of set the weather expectation for the day. As you know, most of these storms they can see moving in. There was no call for a conference call, so our duty officer, who was in the EOC preparing for weather that day, began monitoring their chat room and saw that there were a number of questions rolling in from the other EOCs around the area about, what are we expecting today? We got a lot of picnics, people are out this weekend, with graduations and everything. And they were insistent that, and now this is mid-morning, they were insistent that there was no severe weather expected, that the only thing we were expecting were rain events.
Yeah, just set it up like
An hour or so after that, he again made inquiry, this time calling into the National Weather Service and asking specifically if there was any possibility of severe weather. And they again indicated that there would not be. Checked the meteorologist reports from around the area. They were all predicting rain events. And so he left there and went home. The first of the tornadic events, according to the transcript that the National Weather Service provided him, was about a minute before if you get the phone service, before that went off. He got that, he immediately headed in. So the tone came out at 3:42 from the National Weather Service, and we set our sirens off at 3:53. We set them off again, you're right, there was a second in addition to that, because there was also tornadic activity in terms of rotational winds up along the river in the northern edge of the county, and so they were set off again related to that warning.
Okay, thank you.
Is that standard procedure for somebody to go home when there's threatening weather?
That's the point. There was no threatening weather.
Saturday it wasn't?
There was. They told him twice, once verbally and once in response to an inquiry by the City of St. Louis Emergency Management Director. There was no threatening weather. There was no severe weather expected. That was what they specifically told him. That's why he went home.
In my area, I can tell you this, for what it's worth, I was trying to watch the Preakness, okay? I wanted to watch the horse race, and the sirens went off before KSDK came on with severe weather warnings. So I think ours went out as timely as anybody's, because it wasn't on TV till after the sirens were already going off in Council District 1. So,
to be honest about it, I think St. Peter's was a few minutes ahead of us. 2-3 minutes ahead of us, but yes, we were delayed a few minutes. We are, by the way, in the process of acquiring the equipment to be able to set them off remotely from the cars. We used to have that capability. The equipment was malfunctioning regularly, sending out false positives, and it was disbanded, they tell me, down in emergency management some years ago. So they are, in fact, in the process of acquiring it to be able to set it off remotely. They've been studying out how to do that, and it had come to a conclusion recently about how they could get it done, and they've ordered the equipment.
So the director would be able to set it up from his automobile?
From his automobile, actually, exactly.
Okay.
Motion to dismiss.
Any other comments, announcements?
I hope you get an extra special medal or badge or whatever for sitting through this meeting tonight, Mr. Scout. You did it. You did an excellent job, and you hung it out where your buddies left about 35 minutes ago. So nice job, young man, of hanging in there.
Okay.
Mr. Chairman.
Yes.
I just have one thing to say. I want to congratulate Mr. Brazel for working so hard with the wineries on this particular issue, and
I was going to wait to congratulate him once we get it finally.
I know he's going to work hard on this, but I just hope when he does come back, and they come back and everybody gets together, I just hope there are no sour grapes.
Oh, that whole introduction was for that one-liner.
Yeah. Motion to dismiss on that one.
Motion is made to end the meeting. All in favor say aye.
Aye.
The ayes have it.